All right, this case number 19 CR 009, State of Ohio versus Donald S. Nicely. You are Donald S. Nicely appearing there for the jail.
Yes, sir.
All right, Nicely was convicted of aggravated possession of methamphetamine, third-degree felony, and was placed on due control in the drug court docket on October the 11th, 2019. There had been a holding of the period of due control back in August of 2021 after the defendant was cleared to be transferred. And understanding is that you were convicted in Fayette County and sent to a prison term, and that's why we brought you back to prison. Is that correct?
Yes, sir.
Okay. Right, Mr. Nicely, the court has a notification of a violation alleged was filed by Mr. Carr this morning. Alleges that you have violated Rule 1, then on or about 4/14/22, you were convicted of Fayette County, failure to comply, felony third degree, and having weapon under disability, third degree felony. Rule 2 alleges that on or after 8/3/21, you failed to call in, report as scheduled, and then do it on or after 8/5/21, you failed to report the person scheduled. Rule 3, on or after July 15/21, you failed to report correct address of the probation department. Rule 6, as you were convicted of a felony in Fayette County with a weapon. Rule 7, that on or before 7/29/21, you used methamphetamine and amphetamine. And then Rule 13, and on or after 7/30/21, you failed to complete assessment for further treatment at another change. That was signed by Mr. Carr today. I see signature over there to the left of his signature of your, looks like your signature. You signed this document, looking at this notification.
Yes, sir.
Okay. All right, now, Mr. Nicely, the felony you were convicted of is third degree felony, which carries a possible prison term between 9 and 36 months in the increments provided by law. There's also a possible fine of $10,000. Now, you are entitled to have a hearing on this matter, and this isn't the hearing which scheduled. This is just to notify you of your alleged violation. And so you have a right to actually have a hearing in which the state will have to present evidence through witnesses to prove to the court that you have committed these violations. You have a right to cross-examine those witnesses and present evidence on your own behalf and testify on your own behalf. You have the right to have a reasonable period of time to prepare for a hearing. Usually it's about 2 to 4 weeks where you would have time to consult with an attorney. You have a right to have an attorney, and if you can't afford to hire one, the court will appoint one for you at no cost. Now, in the event it's found that you have committed these violations, I can do one of 3 things. I can continue your community control of the court, although since you're in prison, it wouldn't be effective, it would be total. That's the first option. The second option is to continue it with additional conditions I think are appropriate. Or the third, the most serious option, is that I can terminate you from the drug court docket and terminate your community control and sentence you to prison for between 9 and 36 months in the increments provided by law. Now, you understand the possible consequences of being found to have violated your community control and drug court conditions?
Yes, Your Honor.
And you understand the allegations that were filed against you here by Officer Carr?
Yes, sir.
Now, do you wish to have an attorney to represent you in this matter?
No, sir.
You understand that if you cannot afford to hire an attorney, that the court would appoint one for you at no cost?
Yes, sir.
Let's see here. Well, if you are And you understand that if you don't have an attorney, you will have to make your own decisions regarding, the process we will go through in this hearing.
Yes, sir.
Okay. And you're willing to do that without benefit of counsel?
Yes, sir.
Well, I received a fax from you that has a waiver of counsel form, and I'm trying to, here it is. All right, here's a piece of tape. All right, so, I have received a fax at 1:06 p.m. today from the jail, has your number or your name on it, and it says, "I, Donovan S. Nicely, defendant herein, the now open court, fully understanding the laws of the state, I have a right to legal representation. I do hereby permanently waive my right to be represented by counsel." And then right below that, there's a line that says, defendant underneath it, and that looks to me like you signed this document. Did you sign this form that I just read to you that waives or gives up your right to have an attorney?
Yes, Your Honor.
All right, and this would be put in the file then to show, document the fact that that's what your decision was. Did anyone promise you anything, or threaten you in any way to get you to give up your right to have an attorney in these proceedings?
No, sir.
You're doing this of your own free will and accord?
Yes, sir.
And knowing that it could result in a prison term if you are found to have violated these conditions.
Yes, sir.
Okay. All right. You have any questions at all then about the waiver of counsel?
No, sir.
All right. Next step in the procedure then, Mr. Nicely, is to either admit or deny the allegations. It's kind of like a guilty or not guilty plea. Denial is that you're saying that I'm not admitting to the I want to have a hearing and require the state to prove the violations and to have time to prepare a defense and test the violation. An admission is that you're admitting the allegations that I read to you in that written notice that was filed by Austin Carr earlier today, and admitting that you committed those violations, and then that would subject you one of the three options that I mentioned, including having your food control and drug treatment or drug docket participation terminated and being sent to prison for before you die in 36 months.
Yes, sir.
And I did mention it earlier, but if that occurs, sentence could be ordered to be served. Secondly, the sentence you're serving now on the back end. You understand that?
Yes, sir.
All right. You have any questions then about the allegations?
No, sir.
You have any questions about the consequences if you are found to have committed these violations?
Just that is my jail time credited from STAR and the county that I have done time, will I go towards it?
You'll get all that, guy.
All right.
Okay.
Thank you, sir.
All right. Then do you admit or deny the allegations then, Mr. Nicely?
I admit.
All right. And how many days did you do in STAR?
I think I did 120, but they said when I completed that if you do complete the program, it takes off 6 months. I didn't know if that was true or not, but that's what they said there.
Well, no, the 180 is maximum, but they don't, the state doesn't want to keep people past 120. You say you think you did 120 days?
Yeah, I'm pretty sure I did. I think I might have did 4.5 months. I broke my foot somewhere. I think I had a month and a half left, and I broke my foot then, and they let me out.
Oh, okay. All right. Well,
But they successfully.
I'll find out what that is. Let's see. It looks here like you were ordered to go there on April the 7th. You were to be transported, 2021. Let me see here. Maybe there's a report here from the probation department that says when you got out.
I think it was July 20 something.
What day?
July 27th, maybe, or 22nd.
All right. I'll check on that. But whatever the time is, we'll make sure you get credit for that. All right. Well, the court will find that defendant has admitted to the violations, and the court will also note that Mr. Nicely had previous violations, and that is now serving a prison term. And so it's a judgment of the court that the defendant be terminated from the drug court docket, and that committee control be revoked. Is there anything you'd like to say before I pronounce the sentence, Mr. Nicely?
Yes, sir. I know I gave you enough chances, and really you have given me enough chances, but since I've been in prison, I took the GED test, I'm set to do that. They've asked me if I want to do programs, I'm going to try to do programs in there. See, this prison time was kind of knocking into my head what I need to do. And, I mean, if you could run it together, I'm doing 2.5 years for Fayette County right now, but if you can give me another chance with that, I'd appreciate it.
Okay. Well, it's a judgment on the court that you be sentenced to a term of 24 months in prison. You be given credit according to the sheriff. From your previous time, you have 53 days of jail time credit. You'll get that plus the time from April 7th of 2021 until your completion date is started. We'll confirm that and add that to it. If that's in July, that'd be like 90 days or so, but we'll find out what that is and we'll add that. Now, upon completion of this prison term, Mr. Nicely, the Adult Parole Authority does have the option to put you under close police control supervision for a period of up to 2 years. They don't have to, but if they do, you'll be supervised on the term they set by a parole officer. If they determine that you fail to comply, they can return you to prison to make you serve an additional period of up to 9 months for any one violation. There is a limit of half of your prison term for all violations. However, community felony under close police control supervision, then in addition, whatever sentence the judge in new case proposed money, that judge will also authorize a sentence in this case. Or for committing that offense while under supervision in this case, for additional period of 1 year, whatever time is left on the close police control, whichever is greater, that occurs, it has to be served consecutively sentence in this case. Now, the sentence in this case is ordered to be served consecutively to the Fayette County case, since those offenses were committed while you were under community control in this case, and that they are part of 2 different courses of conduct, and one single sentence is not accurate, but the seriousness of the offense or the harm caused by the offenses, and the criminal history conduct in the case that's an appropriate sentence to protect the public. You're also going to pay the court costs, which has to grant execution order. If you don't do that, then the clerk can collect after various means, including letting on bank accounts, waivers, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, after you get out, or could order you to do research to give you credit for each hour you work, and I already said before, each hour you work will reduce your judgment by that amount. Now, I don't know what the Judge Bettler's intentions are up there for judicial release, if any, but if he were to decide to judicial release you, I would most likely go along with that, but you'll have to deal with him first because he has the first sentence. So there's no point filing here. But what I do doesn't mean is that I wouldn't grant it until we have it from the other court. If he does, then I most likely would grant it if Fayette County does. If they don't, after you complete their sentence, the court will again consider granting you judicial release and putting you back into a treatment program, perhaps even back into the drug court docket if you're interested in that. But again, that depends on you. Obviously, you have to request that, and if that happens, there'll be a hearing. There'll be an evaluation made, and I could have a hearing, or I could decide, to deny without a hearing. But it'll just be kind of what the situation is at that time. But you did very well for a good period of time, and then you just had a number of continuing problems, and just see it keep going downhill. Hopefully, you're going to take the time in prison to reflect on that and to take advantage of the opportunities for programming that will help you come out. But at least, I will consider judicial release if Judge Patrick grants one, or if he doesn't, after you serve his sentence, then I will certainly consider, not promising you're gonna get it, but I will certainly give it a serious consideration. All right?
Thank you, sir.
Questions?
No, sir.